So you need to build, so this is data security. So what I just mentioned, does anyone have access to information? If I enter HR, can I look at anyone's file? If I enter this particular business, it's a health business, can I see anyone's medical data? It's so important for you to understand this, the record. You need to really put everything in place. So following that, I did mention about data subject rights. So this is a topic on its own, but you must understand that data subjects have got various rights, and it's not very easy to implement these. There are various rights. For example, one of the rights is a right to erasure. If a data subject asks you to delete their information, one of the rights is a right to see the information they have. Now, the question is, yes, you know the rights, but how do you implement them within your organization? You need to know how to do that. Third-party processing oversight. So third-party processors, the cloud, you have that. You have suppliers, anyone who is a third party, someone who is not you, anyone who is processing personal data, the third party, and the person that is not you, the processor. You need to have oversight over that. If you're asking someone to process personal data on your behalf, have you done a risk management to understand what's happening there? Do you have a contract in place? You need to understand this. So you need to look at all the third-party agreements you have. Are you giving third parties any personal data to process on your behalf? You need to do that analysis. Then you need to have privacy notices. So what this is basically just transparency. People need to know what you are using their personal data for. You need to obtain consent from people. A privacy notice is just basically transparency. Who we transfer the personal data to, what we do with that personal data. You need to have this in place. It's very, very important. And last but not least, you need to build awareness within your organization. You can have all of this, you have the leadership, but if your people within the organization, if they don't know what to do, this will fail. So you need to train people. What's recommended is you train people during onboarding, or you train people during onboarding, and also training people once a year, at least once every year. So that's very important, because even when it comes to registration, you are required to renew your registration every single year. So you also train people to ensure that they understand that this privacy program is working. You need to train people. You need to build awareness within the institution. Those people that are dealing with vendors, your marketing team cannot be careless. They cannot just send emails to people anyhow. Was consent obtained? You need to build that awareness within the organization. So this is just basically what you need to understand, what you need to start putting in place in order to map. Yes, all these steps do require, I think, there's more to it, but this is a starting point of what you need to begin to put in place, because this applies to sole traders, this applies to startups, it applies to businesses, unless the commissioner says you are exempt. But at this stage, you need to just take the default that it applies to you, even if you're a sole trader, if you are collecting personal data. So the next step, I would like to take you to cross-border transfers. I had mentioned sensitive personal data. So you need to understand that for sensitive personal data, as I said, it has to be stored and processed within Zambia. That's the starting point. So however, when it comes to general personal data like names, and I had given the example of payroll processing outside Zambia, people are part of a group. So what happens in that case? For personal data, which is not sensitive, it is possible to transfer it outside, but you need to obtain consent. I had also mentioned the privacy notice says you obtain consent from a person, and the Data Protection Act says the consent must be explicit. You cannot hide that consent somewhere down. If you are hiding it and the commissioner sees you have not complied, it has to be explicit. The person has to understand what they are consenting to. They consent to you collecting it, storing, to you transferring it outside Zambia to third parties. And following that, you also need to obtain consent from the Data Protection Commissioner to transfer it outside. That's also one of the things you need to do. Then also, if you use data within a group, you also need to have agreements. So there are various things you need to have in place. The commissioner will also want to see, because you need to apply to the commissioner to transfer, he'll want to see what safeguards have you put in place in order to protect this personal data, because you can't be applying to the commissioner anyhow. No, you need to have things in place when you're applying, where you explain why you need to transfer it and what safeguards are there for the particular data subjects. What countries is this going to be transferred to? For cloud, where is this going to be stored? It's so important for you to know this. That's why I had mentioned the governance. When you're doing your risk assessment, you know what's going on. When I said third-party processors, the vendors, you need to understand what's going on, because when you are making this application, the commissioner will be looking at these things. So it's important to understand, even for the cloud, you need to know, where's the residency? Is it in a jurisdiction which does not protect personal data at all? Do you think the commissioner will agree to that? You need to know who is going to access this personal data, what safeguards. So it's important to know this. So as a starting point, when it comes to cross-border transfers, you need to do that differentiation. That's why I belabor to explain the difference between personal data and sensitive personal data. You need to do that data mapping from the onset. That's something that's very, very important. Then lastly, I would just like to take you through the vendor and processor risk. So it's tied closely to this cross-border transfer, but also it's also separate, because this can also occur here in Zambia. So what are you looking at in this context with respect to this? So as I had mentioned earlier, if you are the controller, the person that collects the personal data, the one that is collecting from the people, and you've told these particular people, this is how I'm going to use your personal data. You've obtained their consent. You are accountable to them, the data subjects. So even if you engage a processor, even if it's a processor who is registered, it's important to understand that the controller does remain responsible for ensuring that third-party processing complies with the Data Protection Act, despite the fact that the processor is registered. You need to do your due diligence on your processors. That's the risk assessment. You need to conduct that due diligence. You need to understand, are they registered? Where's the data residency? Where's this data stored? What's the security? You need to understand. Breach notification. You need to make sure that they can notify you if there's a breach. How will they notify you? You need to have that. You need to have a contract in place. Contract readiness is so important. The contract must specify the security measures, the approvals, the audits, notifications, all these things. So this is an ongoing risk assessment. This is something that is ongoing. You maintain a risk register. You need to classify your vendors. You have different vendors. You need to classify them. You need to conduct regular audits just for you to be able to mitigate risks. And then you register. This will help you improve. So this is just the starting point. So just in conclusion, the key takeaways that I want you to take from what I've said in relation to data protection. As a starting point, understand what personal data that you are using in your business. You need to understand it. Review your third-party agreements. You may need to amend them. You need to be ready for breaches. How do you report? And remember that not every breach is notifiable. That's why I had mentioned that there needs to be a senior person, because the senior person is the one who will determine whether or not to notify to the commissioner. The notification is not just anyone within the organization. You need to have something within the team where when you are training them, the people you are training should not be rushing to the commissioner to just report a breach. No, they need to know the structures. Who do they report breaches to? And that particular person will make an assessment on whether or not the breach is notifiable. So that's something that's important. So even so what's important here is training. When people are trained, they will know what to do. Your business will be compliant. If you are a sole trader, you need to understand the compliance. You need to comply, because some people might be wondering, why should a sole trader be compliant? So I'll ask you this: if a sole trader is processing thousands, if their business is to process thousands of records of health data, which is sensitive personal data, shouldn't that particular person be regulated? You can have a person who is just processing a name, and the risk there is very low. But a sole trader, a person who is working alone, processing very, very high risk information, that's something that we see. So it's so important to understand the act, and not just to say, no, I'm a smaller business. The business that you are undertaking, maybe your software, you may be processing a lot of personal data. So it's not really about the amount. The starting point is, are you collecting personal data? Are you using it? How are you using it within your business for you to know whether or not you need to be compliant? So once you're doing that, please register now. Register as a processor, register as a controller. You need to do that determination. You need to understand the localization rules. You need to fix things within your business, update your contracts, and then start rolling out the training. So please, this is not, I think at first it sounds daunting, but once you begin to be compliant, you'll find that it's not something difficult. So please start. I think these are the steps that we wanted to just share with you. If you have any questions, please feel free to put the same, I think, in the chat box. From my end, I think this is it. Over to you, Kasiku, and thank you so much, everyone, for attending.
Thank you so much, Chimwemwe, for that in-depth into data governance. You've highlighted very crucial aspects of what a business needs to adopt a very strong data governance frameworks to manage data privacy, security, and compliance with regulations of the Data Protection Act. And right about now, we will open up the floor for your questions. I have seen there are quite a number of questions in the chat. Please do feel free to submit the questions that you have, and we'll address them during this particular session of our Q&A. So I guess we can just go ahead and dive into the Q&A session. We received quite a number of questions already, so we can just start with this question from Sam Mwase. Sam is asking, when a trademark is made and there is a 60-day period, how does PACRA notify that a mark has been applied for trademark? Where is the notification made so you can object? I'll open up the floor to Nabanji. You can go ahead.
Thank you, Kasiku. And thank you to Sam, I believe, for your question. The starting point is that PACRA will not, in fact, notify directly a trademark owner or holder of a potential conflicting or similar trademark. What they do is, once they've assessed the application and in their view, they find that it is not likely to cause confusion or deception, they'll proceed to publish the mark in the Industrial Property Journal. Now, this is a publication that's available on the PACRA website, and it is published monthly. And the idea is for any trademark owners to proactively review the trademark journal or the Industrial Property Journal and assess or determine whether there are any marks that are likely to infringe their existing trademark. In much larger jurisdictions, you have what are known as trademark watch companies, which essentially perform this service for you at a fee. So they'll monitor all local, regional, and even international trademark offices to determine whether or not there may be a mark that is likely to infringe your trademark and inform you promptly so that you can proceed to object to that particular application. Thank you.
Thanks, Nabanji, for that answer. We also have another question. There are quite a number from Venus Pay Inc. But we will take one from the four so that we can just address the other questions. They're asking, in Zambia's regulatory environment, particularly under Bank of Zambia oversight, how should fintech founders align IP protection with mandatory disclosure requirements without weakening their proprietary advantage?
Thank you for that question. So the financial industry and fintech really is a highly regulated sector, and there are numerous disclosure requirements and regulations that apply to that particular industry. As I had earlier intimated, intellectual property is considered an asset and is private property owned by the creator or the individual owner of that particular work. In terms of fintech companies, your disclosure extends to the required information as far as the regulations is concerned. However, it would not relate to actually disclosing for example, copyrighted work that forms part of your business operations. So in any case, if you so wish, you may indicate even in documentation that this particular work is subject to copyright. As I had earlier stated, you are the one that puts the other party on alert to ensure that that right is in fact enforced. So whatever the case may be, if there is an existing right, it is your duty and your obligation to ensure that that is clearly indicated in all communications involving whether it's copyright or trademarks or any other rights. And so I think that would be the best way to ensure that you protect your proprietary interests whilst also ensuring that you are compliant with the legal regulatory landscape as far as disclosure is concerned.
Great, thanks, Naranji, for that. I will take, in the interest of time, I will take two more questions. You can still send in all the questions that you have. All these questions will be compiled and response will be given to all our participants, both on the Zoom call and those that are joining us either on Facebook or on our YouTube. And if there are any questions, as you can see on the screen, we do have the contact details for MOIRA. You could simply just reach out and they'll be able to assist you. We have a question from Baxton. Can data collected during business operations be processed so that it becomes anonymous? What are the guidelines from the Act on using anonymous data later used for business products development? I think this one's for Chimwemwe.
Thank you, Kaseko. So in relation to, I think, anonymization, so this is an aspect of, I think I'll mention security. So when you collect personal data, the Act does require that you store it in a secure way. So this could be in an encrypted way, this could be in an anonymized way. Even when you're transferring it, you need to, I think, put certain security safeguards in place, even when you're transferring it to a processor. So the Act does regulate that. I think it's something that you need to know. So the guidelines that are there are basically that for a particular organization, any organization, when you collect personal data, you need to collect it, you need to secure it in a store in a very safe way. So you can encrypt that data. And then in relation to what you've mentioned, anonymization, I think, is different from the point at which when you're destroying data and you want to put it in a form where I think once you make it okay, so for data protection, I think I want to make this clear. There's a way you store personal data in a manner that people cannot access it, but there's also a way you store personal data where you don't necessarily delete it, but you put it in a way that that it cannot be reversed. Once it's anonymized, that particular personal data cannot be reversed. I'm hoping that people who are not, I think, who are not in the IT sector can understand. I think for startups and everyone to get that. The idea is that when you are storing personal data, store it in a secure way. It's important to do that. How do you do it? You can anonymize that particular personal data. You can do that so that people don't easily have access to it. Then people are going to, then a question that comes is, what about if someone wants to use that personal data? Only specific people can have access to, for example, it can be an encryption key that can be used to ensure that that particular personal data is, I think, can be used to identify a particular person. I hope that's clear. I think that's a security element that we will deal with in subsequent sessions. But the idea is to understand that the Data Protection Act does regulate that. The anonymization, it does regulate encryption, anything to do with trying to ensure that personal data is secure. That's what's called processing of personal data.
All right, great. Thank you for that response. We have one of our participants from Facebook, Frank Zambo, and this will be our last question for this particular session. Say I have a subscription-based software that also offers enterprise-grade modifications. That is the way companies like Coursera or Udemy or Zoom will offer versions of their software features to be used in private environments, corporate environments. How do we protect ourselves legally and maintain ownership of said modifications if possible?
So that's a very good question. And I think that goes back to the cloud-based aspect. The starting point is you need to look at the specific contract, because this contract should set out exactly how this particular personal data is stored, and even in relation to sharing. With, I think, the cloud-based programs that you've mentioned, you might find that with the access that you have, you are sharing the same with other individuals. You need to be able to understand that. But a challenge that we've seen is that I think we see a lot of that in data protection is really a lack of transparency, but it's important for you to have that appreciation, to know exactly what's happening with that personal data, how it's being stored, even in relation to the security. So that happens in relation to the contracts. You need to do that risk assessment in order to protect yourself. So you need to see, even this particular entity, is it a regulated entity? What cybersecurity measures has this entity put in place? What security measures? You need to do that complete risk assessment. You need to do that for yourself, because this is a third-party processor. Once you do that particular risk assessment, then I think you can make the necessary decisions. So when it comes to data protection, depending on the personal data that you are disclosing, what you're using, it's very specific to the entity. It's very specific to your business. So you'll be looking at your particular business and you'll be asking, what's the risk of this personal data? If I'm going to be using this particular cloud-based institution, what risks could be there? So you need to do that assessment. But the starting point, as I mentioned, look at the contract. You need to also really read their privacy policies, because we review a lot of these privacy policies, and what they contain they really say a lot, where they mention that they can practically sell your data. So you need to understand, or they might have these clauses which say we will not be liable, just clauses which will not protect personal data at all. So you need to do a complete risk assessment. You need to read the agreements, understand the agreements. You need to do that in order to make that assessment. So once those agreements are read with the particular institutions, then you can make a determination, and on your end you can see whether or not you need to continue with the particular with that particular entity in relation to the services that you want to get, or you move to another one. But another issue that comes is data portability, because if you're using this particular entity, we've also seen people ask questions such as, I've already started using them, I've noted these issues, now how do I move this to another entity that is more secure? So that's also another analysis that you need to do. So this is just based on a risk-based assessment, reviewing the agreements to properly understand exactly what's in place and what you need to do to protect yourself. But it's a very, very good question, because when it comes to all these cloud-based services that we all receive, there's a lot of risk. There is a lot of risk. We use Gmail, we use Teams, even you've mentioned Udemy, all these things. So there is a lot of risk. So thank you very much for asking that question. The starting point is to look at the contract, to look at the policies, and then from there, you can make the assessment in relation to what you need to do.
Thank you so much, Chimwemwe, for that. We have taken note of all your questions. I know there are questions from Tenge, Raven, Fanelli, Walia, our viewers from Facebook, Margaret, and everybody else that has posted a question. Unfortunately, in the interest of time, we will not be able to address all the questions on this particular call, but all the questions have been taken note of and they will be answered, and all the answers will be sent to all the participants. So please do look forward to receiving responses to your questions. So as we wrap up, I want to say a very big thank you to our speakers today, Naranji and Chimwemwe, for sharing such valuable insights into intellectual property and data governance today. I know we are walking away with so much knowledge on this, and I'm sure everybody has gained a lot of important takeaways. This webinar is available on our Facebook as well as our YouTube. So if you would want to still go back and listen and still brainstorm over what has been shared, please do feel free. I also want to say a very big thank you to all of you for joining us today and for your excellent questions throughout this particular session. If you want more inquiries or need further assistance with any of the topics that have been discussed, I would encourage you to reach out to MOIRA Legal Practitioners. They are available to assist you with any legal queries related to these topics, and you can contact them on the information that is on the screen, or visit their office at Zepri Business Park, 2nd floor, along Ali King Carter. So we hope to see you at our future webinars, and we thank you once again for your time and your participation in this particular webinar. Do take care and stay safe, and please do feel free to still post your questions even on the webinar that is being broadcast on our YouTube, and once we gather all the questions, we'll be able to address them. Thank you so much once again. I will now open up the floor to our speakers to just say a few things before we close the webinar.
Thank you so much, everyone, for attending. We're so grateful. So please, if you have any questions, please feel free to, I think, send them. You can send them to Bongo Hive or to our business line. We'll be very happy to help. I think, as you can see, Naranja and I are very, very passionate about compliance. So if you need any help, or if you just have any questions, please feel free to reach out. We would be very, very happy to assist you. So for me, it's good night, and we will see you again, definitely, because there are some more sessions that we're going to have. And if you have any particular burning things that you would also want us to address, please feel free to also send the same to us, and we would be happy to sensitize you on the same, because our goal is just to ensure that your business is protected, that you are compliant, and that everyone is making profits without just paying penalties, because the penalties of non-compliance are steep. And if someone steals your intellectual property, as Navanji says, you'll lose out. So thank you so much for attending this session. Over to you, Navanji.
Yeah, I do not have very much else to add. Thank you, everyone, for attending. Thank you for your questions. We'll be sure to respond. I can see that we received quite a lot. And yes, very happy to assist as you navigate all these legal and regulatory landscapes that are constantly evolving, constantly developing, and constantly asking you to comply with quite a lot of things. So yes, it's been an enjoyable session, and I wish everyone a good evening. Thank you.